Okay, well, numbers are still going up, but I now make it 2 minutes past, so we'll begin. Can I just double check with Luke, who's in control, that we have gone live now?
Yeah, we're live.
Thank you. Ladies and gentlemen, welcome to this interactive webinar session on the enforcement of international arbitration awards, focusing on England and India. I'm Duncan Bagshaw. I'm a partner at Howard Kennedy and head of the International Arbitration Group. We are very honored to be hosting this event with our friends Amachand, Shardul, Mangaldas and co. I will be moderating the event with my esteemed colleague Shreya Gupta from Amachand. It's an absolute pleasure to see so many people here with us, and I see from the attendees that they're not only from the UK and from India, but from all over the world. I think that must be a reflection of the great interest in India as a jurisdiction, in arbitration as a subject, and in the standing of the speakers who have attracted you all here. I'm only sorry that we can't see you and that we can't be together, but hopefully before too long we will be able to meet again. We're here really to talk about what is the point of arbitration, not, as some mischievous types might say, a mechanism for lawyers and arbitrators to make money. But the real significance is felt perhaps long before there's a dispute, when parties, governments, companies are choosing arbitration in their contracts or their treaties. And the question is, why do they choose it? Not only because cricket is not a suitable way to resolve commercial disputes, but also we know from surveys that have been carried out that the answer principally lies in the fact that arbitration awards can be enforced directly across international borders. The primary goal of lawyers should be always to avoid disputes. But if arbitrations were not properly enforceable, it would allow parties to breach their obligations with impunity, which could seriously damage investor confidence and bankability of contracts. So a focus on enforcement of arbitration is a natural topic of interest, not only for lawyers, but for companies and businesses, particularly when looking at a fast-growing, future-focused jurisdiction like India, which is of such interest to those doing business there, those investing, and those looking for investment from the subcontinent. Today, we're going to look at several aspects of enforcement and topics related to enforcement, taking into account recent developments in the law. As I say, joining me as my co-moderator is Shreya Gupta, who is a principal associate and specialist in arbitration at Amachand, Shardul, Mangaldas. And we have a stellar panel of speakers. Shreya and I are going to introduce them in the order that they will speak. Before I do, I just want to note for you that the Q&A function is open. We encourage you to put your questions there, and then later we can put them to the speakers after they've spoken. Each of them is going to speak for just a few minutes to introduce their subject, leaving plenty of time in our 1 hour session for questions at the end. So turning to the speakers, it's firstly a huge pleasure for me personally to welcome Arish Barusha. He is my partner at Howard Kennedy. He's recently joined us. We're very delighted to have him, and we're very excited for the future of our International Arbitration and Disputes team with him on board. He is the chair of our India group. He's a solicitor advocate, qualified in England, also admitted to practice in Delhi, and he handles a whole range of international disputes, many of them in the fields of technology, energy, commodities, and also significantly banking and financial services. Our second speaker will be Rishabh Gupta, who is a partner at Shardul, Amachand, Mangaldas, and he leads the firm's international arbitration practice. He's qualified in India and in the United States and in the United Kingdom. He's a solicitor advocate here, so he has rights of audience as well. And he focuses in his practice on domestic arbitration and international arbitration, commercial litigation, and public international law. I'm now going to hand over to Shreya to introduce herself and to introduce our two other speakers, and then to kick off the presentations. Shreya, over to you.
Thank you, Duncan. It's great to be here. I think Duncan's already given enough of an introduction about me, so I'll turn to our third speaker for today, Sudhanshu Swaroop QC from 20SX. Sudhanshu sits as arbitrator and access counsel and has a robust commercial litigation, arbitration, and public international law practice. Welcome, Sudhanshu. And our fourth speaker for today is Karishma Vora, who is a barrister with 39 Essex. Karishma is qualified to practice in India and in UK and has rights of audience in both places. Karishma also has a very busy commercial litigation and international arbitration practice and is very active in cross-border disputes. Welcome, Karishma. Without further ado, I think let's just start with the discussion. Arish, would you like to talk about maybe, the process of enforcement in general and with specific reference to state entities? Do you think there are any go-to or favorite defenses that states opt for?
Thank you very much, Shreya and Duncan, for the introduction and all of the hard work you put into organizing this webinar. I think this is becoming more and more topical at the moment with regards to enforcement and how that works, particularly when state entities are involved. And I'm sure that many people watching this will have been following Cairns' long-running battle with the government of India, and particularly its recent attempts to enforce the arbitral award in excess of $1 billion that it obtained in its favor in a number of overseas jurisdictions, which includes the United Kingdom and the United States. Now, obviously, it's too early, I think, to say precisely what strategy will be adopted and what concerns the parties might have. We will never know. But it's telling that Cairns seems to be targeting public sector undertakings, PSUs as they're known in India, including perhaps most strikingly, and which made a lot of news here in the UK, Air India and its aircraft. So, why might this be? Well, it actually brings back memories for me of a case I was involved in a few years ago, where we were acting for what was effectively a PSU. And in that case, another British company was seeking to enforce a substantial award against the government of India in jurisdictions, again, including the UK and the US. But it found it extraordinarily difficult, coming away not only empty-handed, but with significant costs orders made against them. Now, one of the key reasons for the difficulties was sovereign immunity, which is what I'm going to discuss in this short presentation. And I can only guess that perhaps that is informing Cairns' strategy, at least to some extent, to go after the PSUs. So what I'm going to do is I want to contrast the general ease of enforcement of arbitral awards, which, as Duncan mentioned, is a major selling point of arbitration as a dispute resolution mechanism, with the difficulty in successfully enforcing such awards against sovereign states. So looking first at the sort of general ease of enforcement of arbitral awards, at the heart of the enforcement regime, as many of you will know, is the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards, 1958. At last count, there were 168 parties, I believe, to the convention. And essentially, parties are required to recognize foreign arbitral awards as binding and to enforce them. Signatories must ensure that their domestic regimes reflect the convention. So, although this does not preclude parties to the convention from entering into their own multilateral or bilateral agreements in relation to recognition and enforcement, they must ensure that they also give effect to the convention itself. And what that means, in effect, is that any rules that are separately agreed on by parties which relate to enforcement cannot be more onerous than the conditions that are set out in the convention itself. And moreover, you cannot have substantially more onerous conditions imposed on awards to which the convention applies than are imposed to the recognition and enforcement of domestic arbitral awards. So in essence, what the New York Convention is doing is it's ensuring ease of enforcement, and also that parties, whatever other arrangements they enter into, will make enforcement as straightforward as envisaged by the convention. And to give you an example, in England and Wales, the courts will recognize and enforce arbitral awards subject to the convention pursuant to sections 100 and 101 of the Arbitration Act 1996. And procedurally, it's really quite simple to recognize and enforce foreign arbitral awards. Essentially, the successful party has to apply for recognition or enforcement, which can be done without notice. The court will then grant an enforcement order, which the respondent will be served with. And once the respondent has been served, they have a certain amount of time to try and set it aside. And in keeping with Article 5 of the New York Convention, which is mirrored in Section 103 of the Arbitration Act here, there are only certain very limited grounds on which recognition or enforcement can be refused. And these include incapacity, invalidity, so there's no valid arbitration agreement, a serious procedural irregularity, the award not being final, or that the award is contrary to public policy in the state in which enforcement steps are being taken, amongst a few other things. So I think it's probably right to say that whilst enforcement cannot be seen as a mere formality, and arguments can be had over the enforceability of foreign awards, the regime set out in the convention, as effected in England and Wales, does ensure relative ease of enforcement, particularly when you compare it with litigation, where there are a whole lot of separate regimes, separate bilateral agreements, etc., which some of which can be quite can entail quite complicated procedures and rules for enforcement. But having said that, let's now look at some of the basic rules regarding sovereign immunity here in England, and why, notwithstanding the general ease of enforcing an arbitral award, enforcing against a state can in fact prove very problematic. And the regime in England governing immunity is contained in the Sovereign Immunity Act of 1978. So the first provision that's worth bearing in mind is Section 1. And that states very clearly that in general, a state is immune from the jurisdiction of the courts of the United Kingdom. But there are various caveats to this. And one of the caveats, which is most pertinent for present purposes, is Section 9.2, which says, and I quote, "Where a state has agreed in writing to submit a dispute which has arisen or may arise to arbitration, the state is not immune as respects proceedings in the courts of the United Kingdom which relate to the arbitration." So in essence, if a state has entered into an arbitration agreement, it cannot then turn around and say, well, you can't, I have not subjected myself to the jurisdiction of the courts for the purpose of enforcement. Jurisdiction will be held to have been established if that applies. And there's a case called PAO, Tatneft, and Ukraine, where a bilateral investment treaty entered into by a state was held to constitute such written agreement for the purposes of Section 9.2. Now, you'd think that would be the end of it, but it isn't, because Section 13.2 of the Sovereign Immunity Act says that the property of a state shall not be subject to any process for the enforcement of a judgment or arbitration award, or in an action in rem for its arrest, detention, or sale. And that in turn has its own exception, which says that the provision that I've just mentioned does not apply where the property is to be used for commercial purpose. So just unpacking that a little bit, essentially, we need to distinguish between immunity as to jurisdiction and immunity as to execution. And Section 1 and the caveat to that about submitting a dispute to arbitration and that giving rise to jurisdiction, that goes to immunity as to jurisdiction. The question of whether you can then enforce against particular state assets goes to the matter of immunity as to execution. And what you are left with in practice, therefore, is that even though you might be able to clear the first hurdle of jurisdiction relatively easily, where there's an arbitration agreement, it's much harder to clear the second hurdle, which is about immunity as to execution. What you will have to do in effect is show that the relevant assets that you are looking to enforce against are not intended for use for a sovereign purpose, but instead that they are to be used for a commercial purpose. And this can be difficult in practice. Firstly, it's worth bearing in mind that although this exception exists, a certificate from the diplomatic mission that the relevant property which is being sought to be enforced against, that property is for sovereign use, is taken as evidence of that fact without anything more. And so in effect, what it does is it places a greater burden of proof on the applicant to then disprove that and try to show that in fact the property is intended not for a sovereign purpose, but for a commercial purpose. And that can be quite hard to establish in practice. The second thing that's worth bearing in mind is that many of a state's assets in a foreign jurisdiction will very clearly be protected from execution. Things like the ambassador's residence, the embassy building, those are clearly for a sovereign purpose. And so it can, but even in matters that are not so clear, you will appreciate that the dividing line between what is for a sovereign purpose and what is for a commercial purpose can be hard to establish where a state is involved. So for instance, if the state has set up a company whose purpose is essentially to facilitate and encourage and provide loans to people who are investing in infrastructure into the country, is that a commercial purpose or is it a sovereign purpose? There is clearly a blurring of the line there and an argument to be had about which category it falls into. And all of these sort of increase the difficulties for parties seeking to enforce. Now, some states, in a very small minority, have tried to extend the scope of the waiver on jurisdiction to also encompass a waiver on execution, but that's very limited and potentially open to challenge. The second is that some countries have taken a more restrictive view of what a commercial purpose is. And there are examples even in English case law of the court saying, well, actually, no, this is for a commercial purpose and therefore execution is possible. But the takeaway message is that it remains an uphill struggle and it will be difficult to do. And parties must therefore think very carefully when they are contracting with or investing in states and not assume that enforcement will be easy merely because there is an arbitration clause. So I think I've probably used up my time. I'm going to hand over to Rishabh now, who's going to talk about some of the other interesting issues arising out of the Cairn matter and also another case.
Thank you, Arish. Rishabh, there's a lot of buzz off late about enforcement of awards against the Indian government. And as Arish said, there are a number of different kinds of defenses that are being raised in those disputes. And also equally, there are many different angles that investors are exploring to enforce the awards. Perhaps we could discuss those.
Sure. Thanks, Shreya. Thanks, Arish. And hi, everyone. So what I thought I would do for this very short presentation is that I very briefly talk about two arbitrary awards which have sort of made headlines here in India at least. and flag in each case 4 issues that I think arise out of enforcement of those specific arbitration awards. Now, of course, time is too short to discuss any of those issues in any detail. So I'll just flag them, provide sort of very brief answers, my answers at least to each of those, up in the Q&A session or some other time. Now, the first one that I wanted to very briefly touch upon is Kane v. India. Arish already spoke about that. Just very quickly to recap the facts there, most of you perhaps would already be aware of this, but in 2012, India retrospectively amended the Income Tax Act. As a result of that, tax demands were raised in very large amounts against Kane. Several other companies also received tax demands, but let's keep that on the side. In 2015, Kane commences investment treaty arbitration against India under the UK-India BIT. December 2020, the arbitration award is rendered in the BIT arbitration for about $1.2 billion. 3 months after that, March 2021, India files a set aside at the Hague in the courts there because Hague was the seat of the arbitration. Simultaneously, what Kane has also done, and as Arish also mentioned, they have, according to press reports, commenced enforcement proceedings against assets of certain public sector undertakings, in particular Air India, in other jurisdictions, including the United States. Now, that's sort of just a very quick summary of the facts. What are the 4 issues that I think are interesting that arise from it? The first issue, which you often encounter when people talk about investment treaty arbitration, is that why are we even talking about set aside here? Because aren't investment treaty awards typically immune from set aside in local courts? Now, the answer to that is that in the Indian context, India is not a party to the ICSID Convention. Of course, if it was, then that immunity would apply, and typically you would go for annulment within the ICSID procedure itself. But India is not a party to the ICSID Convention, as a result of which all investment treaty arbitrations against India, and similarly investment treaty arbitrations commenced by Indian parties against foreign governments, tend to be uncitral arbitrations, and therefore the New York Convention applies to enforcement of any of these awards, which then makes it very important that you choose the right seat, because none of the Indian BITs would ever provide the seat for arbitration. That would be up to agreement of the parties, failing which the tribunal would determine it. Typically, Hague is a common choice in Indian investment treaty arbitrations, but increasingly the trend has moved towards choosing Singapore as the seat of arbitration, because the government tends to push for Asian seats as opposed to European seats these days. So that's the first issue that I thought I would highlight. The second issue is that, fine, it's not an ICSID Convention award, it's a New York Convention award. Can it be enforced in India? Now, here actually you can spend the entire day talking about it, because in 2018, there was a decision of Justice Manmohan from the Delhi High Court in the Vodafone v. India case, where what he basically said is, in a very different context, the context there was anti-arbitration injunction. It had nothing to do with enforcement of treaty awards. But what he said is that the Indian Arbitration Act effectively does not apply to anything to do with investment treaty arbitration. And that, of course, would then extend to enforcement of investment treaty awards as well, which therefore would mean that if you bring an investment treaty award to enforce in India, you can't rely upon Part 2 of the Indian Arbitration Act, which effectively incorporates the New York Convention and allows you to enforce the treaty, enforce any award, a New York Convention award, in the same fashion as you would in any other jurisdiction. Now, I've said this in the past as well. I think that decision is wrong. If and when there's an opportunity for someone to reconsider it, for the Supreme Court to reconsider it, hopefully it would be overturned. But until then, you're in a no man's land. Investment treaty awards, no one knows how they can be enforced in India. And to respond to a point that Arish made, why did Kane not come to India? Perhaps it had something to do with that as well, but it could be for a variety of other reasons too. Now, that's the second issue I wanted to highlight, which often people talk about, is that, well, there are set-aside proceedings pending in The Hague. So how can Kane simultaneously enforce the arbitration award? Isn't there automatic stay on the enforcement of the arbitration award? Now, that question often arises because historically under the Indian Arbitration Act, that was the position. The moment you filed a set aside, there was an automatic stay on the enforcement of the arbitration award. But that's not what the construct of the New York Convention is. And unless and until there is either the award has been set aside or there's an express stay on the enforcement of the arbitration award, enforcement proceedings under the New York Convention in other jurisdictions can of course continue. Now, another interesting question arises as to what happens if the award has in fact been set aside at the state court. Now, there, generally speaking, at least the Indian courts have taken the view that they won't enforce arbitration award that has been set aside at the state court. But there are, of course, exceptions. The UK courts have enforced, for example, the UCOS award, even though it had been set aside in Russia. The US courts, famously in the Kromoloy case, enforced an arbitration award that had been set aside in Egypt. French courts have been quite enthusiastic in the past about enforcing arbitration awards that have been set aside at the seat. So there are exceptions, limited exceptions, but that of course is also possible, though in Kane we are not there, because it's not that the Hague courts have set aside the arbitration award. And the final point, which I won't delve into at all, is the point that Arish was making, which is that can you enforce an arbitration award which is against the government of India by trying to execute against the assets of public sector undertakings? And that has, of course, rattled quite a few public sector undertakings in India because they take their separation from the government quite seriously. Now, whether or not that's possible, that's, of course, a question of local law, where you're trying to enforce it. Questions relating to sovereign immunity and otherwise would also come in. But that's a totally different question, which one could spend a full day on again. But that's something which often arises out of the Kane enforcement efforts. So those are the four issues. The other arbitration award that I wanted to very briefly touch upon is the Devas v. Antrix award. Now, ICC arbitration award from a Delhi-seated tribunal, but has investment treaty-related dimensions to it as well. Very briefly, in 2005, Devas and Antrix had entered into an agreement to build a couple of satellites. That agreement was still by Antrix being the commercial arm of the Indian Space Research Organization in 2011. In 2015, what you have is a seated ICC arbitration award, which basically gives Devas about $600 million in damages. Now, not unexpectedly, immediately thereafter, there are set-aside proceedings filed by Antrix in India, and Devas simultaneously tries to enforce the arbitration award in other jurisdictions, including in the US. Now, a couple of developments which happened very recently, I'll quickly mention those because those actually really impact what's happening today. In November 2020, India introduced a special ordinance by way of which they amended the Arbitration Act to effectively say that if the underlying contract that gave rise to the arbitration has been procured by fraud, then there could be a stay on the enforcement of the arbitration award without having to give security. Now, a lot of people believe that this ordinance was introduced primarily to make it difficult for Devas to enforce the arbitration award, because shortly after this amendment was made, Antrix filed an application in the court to effectively say, now give me an unconditional stay. The other thing which they did, which is even more problematic, is that the Antrix, asked the Indian government to give them permission to wind up Antrix altogether. So you have a vague, bizarre situation here where the award debtor is being able to ask the government to wind up the award creditor. And that permission was given. A couple of days later, NCLT appoints a provisional liquidator, this board gets suspended, and suddenly you have a situation where the provisional liquidator of Devas is fighting its lawyers all over the world to stop the enforcement proceedings. Now, not surprisingly, this happened in January of this year. Not surprisingly, a few months later, the shareholders of Devas, the investors in the company, threatened to start an investment treaty arbitration against the government of India, saying that you've effectively treated us in a highly unfair fashion by making it impossible for us to enforce the arbitration award. For those who follow India-related treaty news, this would sound very similar to what where basically you have, in a slightly different way, enforcement efforts getting frustrated. Now, I know my time is coming up, so I'll just flag the 4 issues which I thought I would briefly mention arising out of Devas v. Anthrax, and perhaps we could discuss this later. The first question is, and most of you would have already picked this up, can you enforce outside of India an arbitration award which is otherwise seated in India and is between 2 Indian parties? The answer is, of course, yes, but surprisingly, very, very few people still try that. The second question is that can you seek enforcement of an arbitration award while the set-aside proceedings are still pending in India? This is the same question that came up in the Kane context. The answer is, of course, yes again. The third question is that can investors in a company seek enforcement or can bring an investment treaty arbitration while the company itself is pursuing either an arbitration or enforcement of the underlying arbitration award? And the answer is, of course, again, yes, provided there's no double recovery. And the last question, which I won't, or the last issue which I won't spend any time on, is that can you use investment treaty arbitration as a means to enforce what is effectively a commercial award, which is what the latest arbitration would effectively end up doing? And the answer is perhaps in very exceptional circumstances like this, yes, if you could show that ultimately your international law rights as guaranteed under the treaties are being violated. So I'll stop there, but maybe we could pick this up during the Q&A. Thank you.
Right. I think that brings me in. I want to address today the following question. In what circumstances is the English court prepared to act as an international policeman in order to support enforcement of foreign arbitration awards? I want to answer that question with specific reference to the decision of the English High Court recently in 2019 in the case of ArcelorMittal USA against SR Steel Limited. In that case, the English High Court upheld the grant of a worldwide freezing order and other relief to support the enforcement of an award, even though the arbitration award was foreign, the claimant and the defendant were foreign, and there were no assets within England. I will start by outlining the facts of the case, and then I want to look at the reasoning in a little more detail. So the facts. In December 2017, an arbitral tribunal seated in Minnesota found that ArcelorMittal USA was entitled to over $1 billion in damages from SR Steel Limited in relation to a dispute concerning a contract for the supply of iron ore pellets. As I mentioned, the arbitral tribunal was seated in Minnesota. SR Steel itself was a Mauritian incorporated company. AMUSA tried to enforce the award in various jurisdictions, including Minnesota, Mauritius, the Cayman Islands, and ultimately in England. Accordingly, in 2019, the English High Court granted AMUSA permission to enforce the award as a judgment of the English court. Importantly, for present purposes, it also made a worldwide freezing order and associated relief against SR Steel, finding there was a real risk of dissipation of assets. I should add that in subsequent related proceedings, a different court in England doubted some of the analysis of the evidence in relation to risk of dissipation, but that does not matter for present purposes. For today, I just want to focus on issues of principle that arose from the High Court's reasoning in granting the freezing order. I want to make 6 short points about that reasoning in order to try and convey how the court came to grant an order in circumstances where there was apparently no connection or little connection with England. First, as regards the issue of jurisdiction to make the order, the court found that it had jurisdiction to grant the freezing order simply on the basis that it had granted leave to enforce the award as a judgment of the English court, and it said the freezing order was merely ancillary to that relief, and they said that was enough to engage the jurisdiction of the English court to make a freezing order. The court added that the issue of foreign connections and the lack of English connections, they said that all went to the issue of discretion, not to the question of jurisdiction. Secondly, on the question of discretion, specifically whether it was just and convenient to grant the freezing order, the court accepted, based on existing authority, that in general, it will rarely be appropriate to grant a freezing order to support enforcement of a foreign award where there are no assets in England and where the judgment, where the debtor, the defendant, would otherwise not be subject to the personal jurisdiction of the English court. But thirdly, and crucially, the court considered that in cases of what it called international fraud, the English court should be more willing to intervene. And this was really the crux of the court's reasoning. It's held that for these purposes, international fraud should be understood broadly. It was not limited to the case of a cause of action in deceit, but instead, and I quote, the court said this: if there is a case of serious wrongdoing comprising conduct on a large or repeated scale, whereby a company or the group of which it is a member is acting in a manner prejudicial to its creditors and in bad faith, then I see no reason why the English court should not be willing to intervene rather than to stand by and allow the conduct to continue and, to put the matter colloquially, to let the wrongdoer get away with it. On the facts, the judge considered that there had been an attempt to dissipate an asset worth over $1 billion from SR Steel in the face of commencement of arbitration proceedings. And the court said that on the facts, that was sufficient to warrant intervention under this international fraud exception, regardless of the lack of connection with England as a jurisdiction. Fourthly, the court rejected an argument that enforcement proceedings were a matter for the courts of Minnesota, which was where the arbitration was seated. The court observed there was no evidence that the Minnesota court would have been prepared or able to grant extraterritorial relief, though it noted that had there been evidence, for example, that the Minnesota court would have refused such relief on the merits, then different considerations might apply. Fifthly, there was evidence that the courts of Mauritius, in principle, could grant worldwide freezing orders, but the English court said this was no more than a neutral factor. It observed that as things stood, there was no evidence that the English freezing order would conflict with any order of the Mauritian court. Sixthly, the court noted that there were some links to England. Specifically, a London company called SR Capital Services, it said, had provided professional services to SR Steel and had employed certain individuals living in England. Accordingly, the court concluded there were, therefore, within this jurisdiction, documents relevant to SR Steel's assets, as well as senior people who had been involved in the business in the past and who are likely to have knowledge of its assets and what has become of them. This was an additional factor in favour of the court exercising its discretion to grant the freezing order. Also, this fact formed the basis of the court granting search orders directly against SR Capital Services Limited and certain other third parties. In conclusion, returning to the question that I posed at the outset, i.e., when will the English court act as an international policeman, I suggest, in very broad terms based on this case, the following response: that the English court may well be prepared to act as an international policeman and indeed an international detective in order to aid enforcement of a foreign arbitration award even when the parties are foreign and even when there are no assets in the jurisdiction. And it may be prepared to do so where this international fraud exception applies. That exception potentially, at least on the judge's analysis in this case, has a broad meaning and encompasses a case of serious wrongdoing comprising conduct on a large or repeated scale, whereby a company or the group of which it is a member is acting in a manner prejudicial to its creditors and in bad faith. All of that said, ultimately, as ever, each case will turn on its facts. In this particular case, it was particularly relevant that the asset in question was apparently worth over $1 billion. And other cases, of course, may have different outcomes, in particular, where there is evidence that orders of the English court could conflict with orders of other relevant courts around the world. So that's all I have to say about that. Thank you very much.
Thank you very much, Sudhanshu. That was fascinating, a really remarkable case. Thanks also for knowing to speak while Shreya was looking at me, waiting for me to introduce you. I think it's the mark of a QC that you instinctively know when to speak without necessarily being told. So thank you. Appropriately this time, though, I will introduce Karishma, who is going to discuss interim orders and emergency arbitration awards in the context of enforcement. Karishma, over to you.
Thank you, Duncan. And also thank you, Howard Kennedy and Sam, for organizing this. Rather interesting and very topical at the moment, with a number of judgments coming out of Indian courts hitting the headlines. So what is enforcement? Arish has very kindly touched upon that earlier today. It is basically needed only when an award is not adhered to voluntarily by parties in question. And it gives an arbitration ruling the same effect as a domestic court judgment. Now, before I move on to the crux of what I want to say, which is enforcing interim measures coming out of arbitration proceedings, it may be useful to just very quickly run through reasons to refuse enforcing arbitration awards in general. And the first reason would be that the parties were under an incapacity. So in a recent Indian case called Daiichi Sankyo and Ranbaxy, a Singaporean arbitration award was held to be unenforceable against 2 minors in India, because they were obviously under an incapacity at the time that the arbitration agreement was entered into. The second reason to refuse enforcement is whether an award deals with matters outside the scope of an arbitration agreement, and I will touch upon that as we go along. The third is that the composition of the tribunal was not in accordance with the arbitration agreement. It's one that many of us overlook, and I had overlooked for many years until I found myself in a position where the client said, well, the arbitration agreement needed a cement expert to be appointed on the panel as an arbitrator, but this very famous and reputed arbitration institution has only appointed a barrister, he said, appointed a barrister of England and Wales. Of course, it made me squirm in my seat, but that was quite right. And we were successful in setting aside this award on grounds that the composition of the tribunal was not in accordance with the arbitration agreement. Then there is a favorite of Indian arbitration practitioners, and I might say so wearing or putting on my Indian hat, and that is that the enforcement is contrary to India's public policy. And that, I think, can be a topic that can be debated about for 1 or 2 days. The fifth actually, and the most important for present purposes, is that the award has not yet become binding on the parties. And this is crucial, especially in relation to interim measures. When does an interim measure become binding on the parties? Is it at the time that it's pronounced? But what if it's not final? Is it still binding on the parties? So let's take a few examples here. A procedural order is an interim order. So let's say an arbitral tribunal said, claimant is to file particulars of claim by such and such date, defendant 28 days hence, the claimant files its reply 28 days thereafter, etc. That's a procedural order. Is that enforceable? Well, the answer is, if it is binding then and has finality, then it is enforceable. Otherwise, it is not, and therefore a procedural order would not be enforceable. The second is an award on jurisdiction. We're just going through examples here. An award on jurisdiction, although it doesn't deal with all issues in the case, it does deal with some issues in the case with finality and therefore is enforceable. The third is a tricky one, summary judgments. Are summary judgments pronounced by arbitral tribunals enforceable? Some jurisdictions actually, such as Singapore, consider that an arbitral tribunal does not have the authority to pass summary judgments at all. And Sudhanshu led me in a matter a few years ago before the Commercial Court in England, where we tried to argue that unsuccessfully. And the English court now holds that an arbitral tribunal seated in England can pronounce summary judgments. And of course, a summary judgment would have finality, and therefore it would be binding on the parties and enforceable. The last and rather the most controversial of the types of interim reliefs that we're discussing today is an emergency injunction. Now, it is extremely important because it is passed in circumstances where it is suspected that one party might be alienating assets, for example, and needs to be stopped from doing that. And the emergency arbitrator would say, well, you know, the respondent company is stopped from selling its property or its shareholding, etc. But it would be subject to a return date. It would also be subject to a full tribunal being appointed. And the question is, in these circumstances, is this emergency injunction final? Has it become binding? And if the answers to both of those questions are no, then how does one enforce interim measures which are passed by emergency arbitrators? Now, I think we can go back to the New York Convention again, which Arish very kindly elaborated on, which is the crux of enforcing arbitration awards around the world. And it says, and I'm combining two clauses from the New York Convention here, but if an award has not become binding, it is not enforceable. Now, it doesn't actually mention final or interim anywhere in the convention. And this has prompted, in fact, the UNCITRAL working group in 2006 to amend its model law. And they amended section 17 of their model law. And they said, well, we actually never intended for interim measures to not be enforceable. We just didn't consider it back in 1985 when we were putting out our first model law. And therefore, they put out section 17 in a revised and comprehensive manner in 2006. And they said, these are circumstances in which interim measures can be granted and they're all enforceable. But by 2006, most countries around the world had already enacted their respective arbitration acts. So the question was, well, were they all going to amend their arbitration acts to say that interim measures are now going to be enforceable? Some of them did. India is one of those countries. So by an amendment about 6 years ago in 2015, India said interim measures are enforceable. But this is only, this is what we call part one in India, which means that so long as the award has been passed by a domestic Indian arbitration, that interim measure or that interim award is enforceable within India. But it doesn't say anything, and the Act remains silent on whether interim measures pronounced in international arbitration seated outside India are enforceable in India. Another manner in which countries have taken to this change that UNCITRAL pronounced in 2006 is how England has taken to it. And it's quite nice actually to analyze the difference between the two countries, because England has not made changes to its legislation. Instead, it has, by way of common law and judgments, said if an award is final and binding, then it is an award, it's not an order, and it becomes enforceable. A recent judgment is ZCCM and Kansanshi Holdings, which is a 2019 judgment of the Commercial Court in England, where Mrs. Justice Sarah Cockrell distinguished between an order and an award. And she says, if the ruling finally disposes of the matters, either entirely or in relation to a particular issue, that is an award. not an order. She also said the tribunal's description of the decision is relevant, but it is not conclusive. And this is also important. I've been in a situation where one party has tried to say, well, this particular interim measure does not have the words final partial award. It just says partial award. And therefore, because it's missing the word final, it should not be enforceable. So Mrs. Justice Cockrell has very nicely picked that up and said the tribunal's description of the decision is relevant, but it's not conclusive. She's also said that a decision dealing purely with procedural issues is less likely to be an award, and that the perception of a reasonable bystander, which is perhaps I can say a standard English test in contract. So the perception of a reasonable recipient of the tribunal's decision is also relevant. And she said that how a reasonable recipient would deal with the level of detail in the reasoning, any compliance with formal requirements such as the award must have been signed or in some cases issued on stamp paper, etc. And lastly, whether or not the tribunal intended to make the award. And all of these are relevant to the fact that it is an award as opposed to an order and therefore enforceable. In India, the law is developed slightly differently in relation to emergency arbitration awards because, of course, it has legislative measures, as I have previously highlighted. So two recent judgments called HSBC and Avitel of the Bombay High Court and Raffles Design and Educomp of the Delhi High Court, both were faced with a situation where an interim emergency arbitration award passed by a foreign tribunal outside of India needed to be enforced in India. And in both situations, the parties came to India are seeking a remedy under Section 9, which is a section where a court, a domestic Indian court, can pronounce its own interim measures. So they didn't come under Section 17, which says that interim measures are enforceable because they must have taken the view that Section 17 is only for domestic awards. So in both of these cases, the Bombay High Court and the Delhi High Court said the emergency arbitration ruling holds persuasive value and that there is no reason why both of the courts could not independently come up with the same view as the emergency arbitration award. In other words, they didn't enforce the award, but they did uphold it by passing the same judgment. And lastly, which is one of the most topical emergency arbitration awards that is hitting headlines in India these days, is the Amazon versus Future Group Emergency Arbitration Award. It's a Delhi-seated arbitration governed by Indian law, but it has SIAC arbitration rules that apply, and an emergency arbitrator provided a ruling that said that the Future Group could not go off and sell its assets and shareholding to Amazon's arch rivals in India called Reliance. A number of judgments have arisen, but I'll focus on the last, which is the Justice Midha judgment. And this is of March 2021, where Justice Midha disposed of the petition, which was brought to him under Section 17, and held that an emergency arbitrator is very much an arbitrator for all intents and purposes. And the order of an emergency arbitrator is an order under Section 17, and therefore is enforceable as an order of the Delhi High Court. This was, I think, a very progressive judgment, and in usual style has been set aside by the division bench of the Delhi High Court, and it's up in appeal to the Supreme Court of India.
Karishma, thank you so much. That was very interesting and very topical with the growth of emergency relief and emergency arbitrator awards. I'm going to jump straight into questions because we don't have too much time. Sudhanshu, can I start with you and ask a question which arises quite directly from Karishma's comments, because in the Amazon and Future Group case she was talking about, there was a potential reorganization or movement of assets, which prompted an application for emergency relief. A question that we've had from one of our registered delegates, Kunwar Ajit Singh from Bharat Petroleum Corporation, is how does one deal with an award debtor which seeks to reorganize itself, or a corporate reorganization, which is going to have the effect that assets that might otherwise have been available for enforcement appear to be not long for the company's possession, or otherwise being put beyond reach? Where do you draw the line between that and a deliberate dissipation of assets to avoid enforcement? And does it matter whether this is being done for nefarious reasons to put the assets beyond reach, or simply for legitimate corporate reorganization reasons?
I mean, ultimately, it's going to be a question for all the evidence. But what you, in order to get a freezing order application off the ground, you don't need to show necessarily bad faith or fraud. I mean, the case I talked about, the issue of fraud arose because it was international. It was relevant to the issue of how could the English court act when everything, apparently all the connections were foreign. But if there's a solid risk of dissipation on the evidence, even if you can't show there has been dissipation, even if you can't show existing bad faith, that may well be enough to persuade the court. Certainly in England, I can't speak for other jurisdictions.
No, so following on from that, it may well be that something is being proposed to be done not in bad faith, but with the collateral benefit of putting assets beyond reach, and a court may, subject to the evidence, be interested in looking behind that as to whether that amounts to dissipation that could prompt interim relief. Thank you very much. I'm going to move on to another question so that we get in as many as we can. We've had a question which, Rishabh, I hope you'll forgive me for putting this one to you. I know having worked in multiple jurisdictions and worked on cases which cross over numerous borders, you'll have a view on this. We've had a question from Milap Dolakia, who is at the Gujarat State Petroleum Corporation. Milap asks about specific jurisdictions, but I'm going to keep the question quite general. I hope I'll be forgiven, and say, when you have an award that's been rendered in India, and it's against a corporation or a defendant, a respondent, which has assets in multiple jurisdictions, do you have a preferred strategy in terms of enforcement in relation to which jurisdiction you seek to enforce in? Whether you do it in multiple jurisdictions at the same time, or whether you go for perhaps an anchor jurisdiction, which you seek to enforce in first, and then spread out from there and go to other jurisdictions second? I'm sure the answer will be that it depends to some extent, but what informs your decisions about that sort of thing?
So very broadly speaking, Duncan, there'll be two rules of thumb that you'll follow, or at least I would follow. The first is you trace the assets, right? You follow the money, right? Because there's no point commencing enforcement proceedings in a jurisdiction where either there are no assets or the quality of assets is such that it's not worth pursuing. So when I say quality of assets, you might have great assets in the jurisdiction, but they might be completely encumbered. What's the point of trying to go after those assets? So the first point is find the assets that are worth pursuing. And very often, if it's a fairly large award and the client is willing, the best step to do before doing any of this is to get an asset tracing report so that you precisely know what those assets are. And as lawyers, we are not very well equipped to figure that out on our own. So there are asset tracers out there who can do it. So that's the first rule of thumb. The second rule of thumb is that, of course, after having identified certain jurisdictions where there are quality assets to go after, and let's assume you have now 5 or 7 jurisdictions that are worth, that have assets that you want to pursue. The next question is, do you want to commence proceedings in all of them, or do you want to commence proceedings in a subset of them? Now, New York Convention would typically allow you to do it in all jurisdictions. There's nothing stopping you from having enforcement proceedings on foot in multiple jurisdictions. What really would stop you from doing that is costs and, of course, other strategic considerations. So there, what you would be looking for, generally speaking, is which country or which body of law is most favorable to you. And, you know, there are lots of different tools that come into play here. So one reason why a lot of clients like to do it in the US is because the discovery tools are so extensive. So you can go after banks to get information about assets. You can go after wiring agencies like, SWIFT, for example, to get information. And those are very helpful, which most jurisdictions, including India, for example, won't give you. So I think those are the two main rules of thumb to keep in mind. And after that, it would come down to vagaries of each respective jurisdiction.
Thank you very much, Rishabh. As I say, I knew you would have a good answer for that strategy question. I'm going to hand over to Shreya now, who's going to put some more questions. Shreya, you will have seen that there are some questions in the Q&A box that we could ask.
Next question is for Arish. Arish, there's been a lot of, I think, uncertainty about whether awards are still enforceable in the UK from other EU countries, and would Brexit have an impact on enforceability of awards in the UK?
Right. Well, so this in a sense demonstrates the great benefits of arbitration and the New York Convention, because whilst there is indeed a lot of uncertainty at the moment concerning recognition and enforcement of court judgments after Brexit, because we are no longer part of the EU regime. And it was expected that that would be replaced by something called Lugano, which broadly replicates that. That hasn't happened yet. And so there's a lot of uncertainty at the moment as to whether that will happen. And at the moment, it seems like we've reverted to sort of default provisions in the common law and other treaties that have been entered into. So the position there is quite complex and difficult at the moment. But in contrast, because of the New York Convention, Brexit essentially has no impact on arbitration, because all of the parties who, as I mentioned, a very, very large number of countries have signed up to the New York Convention. That is the convention that governs enforcement of arbitral awards. It's unaffected by Brexit. And so whether a party is within the EU or outside of the EU, as long as they are part of the New York Convention, they will be able to enforce in a very straightforward manner in England. And we're expecting as a result to actually see more arbitration agreements going into commercial contracts as opposed to court litigation clauses.
Thank you. The next question is for Karishma. Typically, interim awards or emergency arbitration awards are subject to being varied by either the main tribunal when it's constituted in the cases of emergency arbitrations, or by the tribunal that has issued the interim award. Does that pose as a problem when you seek to enforce the awards?
Yes, I think the question is in what happens when a tribunal passes a freezing injunction. And there are various difficulties with it. To begin with, to ensure that a freezing injunction is really effective, what I would expect solicitors instructing me to do would be to take the freezing injunction and then serve it on various banks, shareholding authorities such as the NSDL or the CDSL in India, etc. And that would put them all on alert that these assets belonging to the particular defendant should not be alienated or should not be transferred. But how does one do that when there is the confidentiality requirement in an arbitration? So I think it is slightly dangerous to get a freezing injunction passed by an arbitration tribunal. Then there is also the problem that the freezing injunction tends to be ex parte. And therefore there will inevitably be a return date. And if there's a return date, then there's no finality. And a jurisdiction such as England, which takes the view that there must be finality for it to be an award, not an order, will not enforce it. So it would be, I think, more prudent for a client in those circumstances to approach courts that are amenable to grant freezing injunctions, worldwide freezing injunctions in particular, such as England, Singapore, the DIFC court, etc.
Thanks very much, Karishma. I'm both pleased and sorry to say that we have probably more questions than we can fit in the time available. I'm going to turn now to a question which has come from Nikhil Boulel in Mauritius. In Mauritius, there is a new decision of the Privy Council that was recently handed down in the Betamax case. Now, the point of that decision was to note that where the arbitral tribunal had found as a matter of law that the contract in question was not illegal because it had not been governed by the mandatory requirements on public procurement, a challenge on the basis of public policy saying that in fact that was wrong and it should have complied with the rules on public procurement, and that failure to do so amounted to a breach of public policy, was not open because of the finality of the decision of the arbitrator. I'm going to throw this open to the panel to see whether anybody wants to comment on this issue of finality of decisions. As we know, it's one of the most attractive features of arbitration, that you can generally rely on the decision being made. But there's a difficult decision, isn't there, between the finality of the arbitrator's decisions and the court's role in policing public policy. Would anyone like to say a few words on where that line is drawn?
I can offer a couple of very quick thoughts.
Thank you.
See, in the Betamax case, to start with, of course, it's just the process which was being followed, right? Because you had the SEAC arbitration award, which I understand was seated in Mauritius. The Mauritius Supreme Court reverses it or sets it aside, and the Privy Council effectively then overturns the Supreme Court's decision. So in terms of the actual process being followed, there's nothing to fault really. Now, the second question is, which actually to Indian practitioners is a very live decision. And I think even the Privy Council decision does refer to a couple of Indian court decisions, is what is the scope of public policy? Yeah? And to what extent that includes questions of illegality, and questions of illegality in relation to what? In relation to procurement of the underlying contract, questions of illegality in relation to how the arbitration award itself has interpreted the contract or the facts. Because in the Indian context, at least when it's seated in India, there is a ground available to set aside the arbitration award, which we call patent illegality, which is nothing but a dimension itself of the public policy ground. And that's widely interpreted as effectively to mean not just that there's illegality in the procurement of the contract, or contravention with respect to any statute, which is what the case is in Betamax, but also to include interpretations of either contractual provisions or findings of fact that are so out of the ordinary that the award must be set aside. And then it's set aside. And most recently, the Bombay High Court a couple of weeks ago set aside the arbitration award in favor of Deccan Chronicle, which owned one of the cricket teams in the Indian Premier League, on that very basis, saying that it was patently illegal because the arbitration tribunal effectively interpreted the contract and made findings of fact which were just totally incomprehensible to the Bombay High Court judge. So I'll stop there. Maybe other panelists have other views, but to my mind, of course, it all depends on the specific facts, but there is nothing on the face of it which would appear to suggest that the process itself is not being followed, because those are grounds available for set aside, as I understand, under Mauritius law, as they are under Indian law as well.
Thank you so much.
Do we have a minute, Duncan? Or
yes, please, yeah. Go ahead.
I also wanted to pick up quickly on the point about finality, because my client was unfortunately on the receiving end of the Cockrell judgment that Karishma referenced in her speech, in her talk. And essentially the issue there was whether a dismissal of an application to bring, to obtain permission to bring a derivative claim was final or not. So the procedure in England is you cannot just bring a derivative claim on behalf of a company. You have to seek permission from the court and show that essentially it is in the interest of the company for those proceedings to be brought. The arbitral tribunal had said, no, we're not granting permission for you to bring the derivative claim. And the question here was, well, is that final or not? Now, the arguments to suggest it was final was to say that without that permission, the claim could not proceed, and that was therefore the end of it. Various arguments were of course made in opposition to that, and including that this wasn't a final hearing, there wasn't evidence and cross-examination in the same way. Now, that demonstrates that it is very difficult to determine precisely what is final, and it touches upon some of the issues that you raised, Karishma, in your talk. I'm obviously biased. I thought that that decision was final, but I can of course see that there were reasons based on which the judge found that it wasn't final. But it highlights the complexities and the difficulties in establishing exactly what is final. And there's a lot of gray areas that we could come across in the context of trying to challenge arbitral awards. So there's no clear answer, I'm afraid, that we can give, and it will be very fact specific.
Karishma, I see you're unmuted. Did you want to add a few words?
Just in relation to an ancillary issue that Arish touched upon, which is difficulties with evidence sometimes in such emergence or in decisions pronounced by arbitration tribunals where evidence has not been considered. And another example is summary judgment. So while that has an issue of finality, a summary judgment passed by an arbitrator, it can be, one can question enforcement on grounds that the process of natural justice hasn't been followed because evidence hasn't been produced before the arbitrators, and can that be questioned on public policy grounds? So, so there is a very serious interplay, and as Arish quite rightly said, it's also all dependent on the underlying facts in issue.
Thank you very much, Karishma. I think much as we would all like to hear you speaking more and to discuss other topics, I think we must allow everyone to get back to their work and bring the session to a close. I want to thank all of you enormously for fascinating contributions. And to close the session, I'm going to hand back over to Shreya for a last remark.
Thank you. Thank you, Duncan. Thank you to all the speakers. I think we can agree that enforcement is perhaps one of the most important parts of an arbitration, because that's where everything comes together. And well, whether courts are overstepping at times or not, at least most jurisdictions are moving towards enforcing awards and giving effect to the intention of parties and making sure that the entire arbitration process is not in vain. So hopefully we'll see much, much more of that, and much quicker in certain cases. Thank you.
Thank you, Shreya. Thank you to our guests, Sudhanshu and Karishma. Thanks from Howard Kennedy to Amachan Shardul Mangaldas for hosting with us. And thanks to everyone who joined. We'll bring the session to a close there. Please do contact us individually if you have any particular issues that you'd like to discuss with us, and look out for a short note discussing the areas of our session that we're going to publish afterwards. I would ask, if you are commenting on the session or quoting from it, we would prefer that the remarks of the individuals aren't attributed, because they've been offered for discussion purposes rather than as advice. But I do hope you've enjoyed them, and we look forward to seeing you all again soon. Thank you all very much.